Why is Egypt's controversial new family law being debated? The draft personal status law, now at the center of Egyptian public life, looks, at first glance, like a technical matter: divorce procedures, maintenance arrangements, custody provisions. A closer look tells a different story. The draft raises real questions about the identity of Egyptian society and the future of Islamic law within the legislative sphere. What does the law change and what does it threaten? Supporters present the draft as reform. Scattered old regulations are being brought under a single umbrella, women's rights are being strengthened, and judicial processes in domestic disputes are being expedited. These justifications sound reasonable enough on the surface. A closer examination of the actual provisions tells the story of a bill that contains elements that will tear Muslim families apart. Start with the conditions forming the basis of marriage. The widely accepted view in Islamic law holds that a young woman should not marry of her own free will without a guardian. The new bill makes this possible anyway, by invoking a minority opinion within the Hanafi school. Modern Egyptian law neither fully applies Sharia nor adheres strictly to any single school of jurisprudence. Fair enough. But socially speaking, Egypt is not a Hanafi country, and its adoption of this particular view is no accident. It reflects a selective eclecticism serving a particular philosophy. Then there is the marriage of Muslim women to Christian men, prohibited under Islamic law, now abolished on the grounds of shared citizenship and common national identity. In the very same Egypt, a Muslim man's marriage to an Egyptian woman of the people of the book remains effectively restricted, because the Church regards such unions as contrary to its own teachings. Guardianship is removed on one side. Freedom is granted on the other. It is as though, under the banner of freedom, Muslim women are being quietly steered toward non-Muslim partners. Another heavily contested provision concerns the dissolution of marriage within the first 6 months. The draft allows a woman to petition the court to dissolve her marriage if her husband concealed information about his education, his profession, or other details that could affect married life. Critics point out that this provision has no real basis in Sharia in this form. Take an intelligence officer who cannot disclose his true profession to his wife because his duty to defend his country demands secrecy, and who presents himself to the outside world as an engineer. Under Sharia, that concealment would not constitute grounds for annulment. Beyond this, critics argue that the draft undermines the man's position of authority within the family on several fronts. The husband's role as the responsible head of the household is rendered meaningless. Divorce is transformed into an individual right, detached from any social oversight. Where does Al-Azhar stand? Amid all this, Al-Azhar, the country's foremost religious authority, issued a surprising official statement on the 18th of May 2026. The institution said it had played no role in drafting the bill. The bill, it noted, had never even been submitted to it. The statement also implied that the comprehensive personal status law draft that Al-Azhar itself had prepared back in 2019 had simply been set aside. The courage to propose such laws belongs, on one hand, to a society's religious leaders. On the other hand, it cannot be judged apart from certain non-Islamic practices that those same leaders sometimes claim as belonging to their society. Take the remarks attributed to the Grand Imam of Al-Azhar, Ahmed Al-Tayyib, circulating in certain video clips, about how divorce affects a child's relationship with the father. Many read these remarks as extending the authority of the mother and custodial parent over naming, identity and care at the father's expense. Yet Egypt's traditional fatwa tradition has long held, in the Shafi school, that the right to name a child or assign a patronymic belongs to the father, not the mother, in the event of a dispute between spouses or in any other circumstance. The debate over whether official religious institutions should act as guardians of Sharia in the face of the state rages on. Meanwhile, certain Madkhali circles within society, those identifying with Salafism, stretch the concept of obedience to those in authority so broadly that objecting to the law starts to look like objecting to religion itself. So should Al-Azhar intervene in cases like this? Muslims might well say yes. Certain secular circles, by contrast, ardently advocate removing Al-Azhar from the legislative sphere altogether, in the name of a civil state and secular governance. Meanwhile, these same circles have not uttered a single word of criticism over the Church's institutional authority over marriage, divorce, annulment, and remarriage for Christian citizens. The background to the debate. All this might look like a product of state policy or homegrown thinking. It is not. The intellectual background to the current legislative push traces back to the International Conference on Population and Development held in Cairo in 1994, and to the CEDAW Convention. The real issue is that women's rights have been turned into a tool for erasing the Sharia-based distinctions between men and women within the family. The father and husband, once partners in building the home, have been repositioned as perpetual adversaries. Scholars such as Sheikh Mohammed Al-Ghazali and the former Grand Imam of Al-Azhar, Ali Gad al-Haq, exposed the aim behind these projects. They perceived them as aimed towards the dismantling of the Muslim family by dragging it into a chase for utopian equality. In Islam, marriage carries leadership, responsibility, guardianship, and mercy. In the projects shaping Egypt's current debate, marriage is being stripped of its sense of guardianship altogether. Divorce becomes a transferable right with no real social safeguards. The family itself is reduced to a partnership that can be dissolved at speed. Now turn to the 2026 draft bill itself. The European Union's Tamkeen program for Egyptian women, launched in June 2024 with a grant of €10 million, was shaped around the goals of gender equality and women's empowerment. Even when reports indicate that the €7.4 billion partnership between Egypt and the EU includes governance and human rights among its headings, none of this can be separated from the draft law. International normative pressure is its foundation. Conclusion: Egyptian family law does have real problems. Complaints about fathers' limited access rights, the unequal application of maintenance obligations and paternity rights, and long delays in judicial proceedings are legitimate and pressing. Genuine reform should resolve these issues. The state can make divorce registration mandatory, regulate financial rights, and penalize those who delay notification or maintenance payments in bad faith. What genuine reform cannot do is eradicate the spirit of Sharia, import the philosophy of CEDAW and Western population development conferences and impose it on personal status against the will of society, or deepen the conflict between men and women. The stakes of promoting laws contrary to Islam in Egypt specifically are high, because Egypt is home to the largest religious institution in the Sunni world. Whatever gets imposed on the Egyptian people becomes, almost automatically, a reference point in the media. The veil controversy offers a precedent. The former Grand Imam of Al-Azhar, Dr. Mohammed Sayyid Tantawi, once supported banning it in certain educational settings, calling it a tradition, not a form of worship. When French President Nicolas Sarkozy declared in 2009 that his country opposed the veil and the burqa, that statement handed Western secular discourse exactly the ammunition it was looking for. If even the Grand Imam of Al-Azhar says the veil is not part of Islam, why object to its ban in France? The same logic applies today to Egypt's draft bill. Every concession made by the Sunni world's most authoritative institution stands ready to be used tomorrow as a weapon against Muslims everywhere.